the entirety of the case or anything.
Right, exactly.
I'm going to deny your request. Continue.
Why?
Excuse me?
No.
Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
Court does call the case of the people versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. I think this is people's motion.
Yes, Your Honor. I'm handling this for Ms. Willenbring. There is sensitive information in the police report that includes victims' contact information at home addresses and birthdays. So pursuant to the court rule, Ms. Willenbring would like to redact that information from the police report, but is requesting order from the court for that effect as well.
All right. First thing, Mr. Jolly, let me just, you are going to continue to represent yourself, sir?
Yes.
All right, I just want to advise you that you are charged with that there are 2 counts on your complaint of criminal sexual conduct in the fourth degree by force or coercion. You understand that, sir?
I understand what the charges are, but never.
Okay. Sir, I have to advise you.
Okay.
You understand that?
I understand.
And that those are high court misdemeanors punishable by up to 2 years incarceration or $5,000 fine plus court costs, mandatory HIV and STD testing.
Okay.
You understand that, sir?
Yeah.
All right. Sir, you wish to continue to represent yourself. The court does have to just advise you and admonish you that I will hold you to the same standards as I would hold somebody that is licensed. You have to abide by all of the court rules, etc. You understand that? All right? And that you won't give any favoritism, and that the court is not in a position and will not assist you if there is something that you don't understand. You are going to be charged with knowing court rules and procedure. You understand that?
But I do.
All right. And I would ask you, or I would also tell you that you do have the right, and if you'd like an opportunity to consult with either a retained lawyer or somebody from the public defender's office, the court would make that occur.
Okay.
You understand that, sir?
Sure.
Okay. Do you have a response to the motion from the people?
I mean, my understanding then is they're going to retract the identification of them, but I'll get the rest of the information. Is it correct?
You would get the rest. My understanding is any identifying information other than name,
Okay.
like address, any phone numbers, anything along those lines would be redacted. Do you have any problem with that, sir?
No, I have no use for that.
What I would indicate is that I will grant the motion as filed by people. And there's also a request, I guess, that the motion hearing will be sealed and preserved for review in the result of an appeal.
Buckle up, guys. Today we step inside a tense courtroom where control is immediately asserted by the judge as a defendant tries to push back during early proceedings. Facing serious criminal sexual conduct charges, he is warned that representing himself means full responsibility under court rules with no special treatment. When he reacts aggressively to rulings, the judge shuts it down instantly, emphasizing discipline, courtroom respect and possible custody consequences, setting a strict tone for everything that follows.
I mean, yes, because that's what the court rule says. It's a funky court rule.
It is.
Because I haven't said their addresses or phone numbers out loud. It's just that the court rule says that if we're going to redact, that this hearing then becomes sealed.
Yes, it does. It does say that. So, I mean, I'll order it because that's what the court rule says. However, none of that information has been provided on this record, so the record is clear. All right.
Okay, I have a question, Your Honor. Like I said, I have no awareness even of an incident or any conflict occurring at all. I've been obedient I've been good on the tether so far. I talked with Brandon Casey, there, my case manager across the street. He thought that I wouldn't have a problem getting off after the first 30 days here.
I'm sorry?
The tether that I have, I mean, I'm a member. I haven't been in trouble, where I've been here for years. I don't have, something to fight. But
So what are you requesting?
that I get this tether off. It's only fair. I've not been in trouble at all in Ann Arbor ever since I've been here. I've been in trouble at all. Not on probation. I have nothing to do with being a trouble with the community at all or anything like that. No witnesses here. So this is just, we grant that, please.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probably cause or anything.
going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
Court does call the case. The people of the state of Michigan versus Cody Lee Jolly. I think we're actually set for, what are we set for? We're set for PCC. All right, state your name, sir.
Cody Lee Jolly.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts of criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory STD testing. You understand that, sir? Yeah. All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that? Yeah. Okay. Very good. All right. So what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. The CD provided to the jail staff.
Yes.
If the answer is no, I don't know how that's.
The court formally lays out the allegations, detailing 2 counts of 4th-degree criminal sexual conduct and explaining potential penalties, including incarceration and mandatory testing. The defendant is repeatedly advised that self-representation means strict adherence to legal procedure. Meanwhile, the prosecution moves to redact sensitive victim information, which the judge approves, reinforcing privacy protections while maintaining the case record.
Okay. Could you put it in? Is that acceptable? Is that okay with you guys?
Yeah, we can switch.
Okay, thank you so much.
All right.
That's
Oh.
everything we have.
That's all discovery. Sir, what did you want to do next on this case?
Before I start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay? That's what concerns me. You're charged with a high court misdemeanor. Okay? The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay? And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Move forward and just I'm guilty and basically work preliminary examinations. Okay. I have this matter. I'm in custody right now. And I was hoping to settle to solve it.
So you want it, you got a copy of the police report, right?
I got the discovery. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible. But the preliminary examination held before that.
Wow. All right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person.
In this matter, the custody includes
Pardon?
The other day I went to the arraignment. I was hoping to get released, but there was I had to come here first. Kind of make released through
What do you mean you?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was
Nice,
on
yeah.
April 5th, 2024. He was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC. He's out on bond in the CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is a violation of his bond, given that he's committing a new crime while he's out on bond, and that's turning behavior in a public place, in a place he's in trespass. My office denied the warrant request and essentially turned to this case and for us to move forward with a bond violation here instead.
As the case transitions into a probable cause conference, the court breaks down the entire criminal process step by step, explaining how the matter moves from preliminary examination to potential circuit court proceedings. The defendant appears confused but insists on moving forward quickly toward trial. Discovered materials are confirmed, and the judge carefully clarifies that the preliminary exam is required before any trial can occur. The court also reinforces that self-representation will not exempt him from procedural expectations.
All right. Sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation. The violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was. They said that it was when they came out and gave me the trespass. When I got here, they said trespass and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. No, nothing weird in the library. I have no idea. But yeah, it wasn't.
But you weren't supposed to be back on the property.
That's what they said. I guess that was suspended from this.
Do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
But I mean, if it's not a new charge, I admit that I was trespassing. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever. I'm not.
Right.
Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. Just, you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
I've never been there before. I was aware that it was allowed to be in public library. I've never been to do it.
Sir, did you want a hearing on the bond violation? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just find the stuff we can get heard. Simple as that. I've done like 10 days in jail already. And
where are you coming up with this 10 days in jail?
I just got to get out.
Yeah, but what do you mean I've done my 10 days?
I've done 10 days so far, and I've not actually been charged. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Okay, but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what it's telling me.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
The best I can. I've been 2 months without a problem. Best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you're going to have a hearing on it. But then the issue becomes, are you going to try to handle this hearing yourself? Or are you going to want an attorney to assist you with that?
Tension escalates when new allegations surface involving trespassing at the University of Michigan, while the defendant is already out on bond. The prosecution frames it as a direct bond violation, potentially changing custody status. The defendant initially minimizes the incident, but eventually admits to violating conditions. The judge repeatedly warns him that this hearing could determine whether he remains free or is held in custody pending trial. Despite being advised to seek counsel, he chooses to proceed without an attorney, increasing the stakes as the court schedules a dedicated bond violation hearing.
I understand that you want to move forward, but there's going to be a hearing that's going to determine whether or not you're in custody. Pardon? Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Like I said, I'm just doing my best to live my life.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm gonna let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's gonna be held on this case. I'll give him a bond of some type, but he's gonna be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out of some class. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just looking out the facts.
Just answer my question.
Yeah, just
You're gonna handle it yourself. Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then because the following week is his, what day?
So we would have Tuesday morning available.
The 16th.
But he's in custody, so I'm gonna do that. Because that's pretty much the house. Once you did it,
What? I got stuff Tuesday afternoon.
you have an expungement docket at 1, which is small, so you can do it at 2 o'clock.
I could do it at 2 o'clock on Tuesday, the 16th.
It's a U of M police officer, so I can email him, 2 U of M police officers, so I can email them and see if one or both of them can be there on that date.
Okay. What I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So, set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender condition. Because this months, I think, hoping this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't afford cash bonds, just write a PR on it, maybe sign that, got it.
I don't know what you're asking me.
If the tether situation can be addressed on the same day.
I'm going to address everything on any day that you appear. So, if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so I'm going to assume that there's nothing else. Bond will remain.
The court finalizes scheduling, setting both a bond violation hearing and a future preliminary examination as the case continues to build momentum. The judge makes it clear that conditions of release, including the tether, remain in effect pending further review. The defendant attempts to argue for leniency based on time served, but the court focuses on procedure and compliance rather than emotion, keeping the case firmly on track. Like the video, subscribe to the channel, and we'll see you in the next video.